was it the intent of the framers, is it the intent of the property clause of the Constitution to grant an unlimited power to the federal government to own the majority of the territory within a sovereign state?
The understanding when Utah, like other states, entered is the federal government would sell these lands. Not instantly, because that would lower the price. There would be a regular course of sale. And they did that until 1976. They slowed down a bit in 1913.
There is a significant constitutional question as to whether the federal government has the power to permanently retain the majority of the land within the borders of the state of Utah.
Look at the history and say, why did it change? Why did the federal government just decide to? Well, it makes the federal government more powerful.
It is our conclusion that with regard to the question of whether the federal government has the constitutional power to near permanently retain over 66% of the land within the borders of the state of Utah, it is our conclusion that that power does not exist.
That an equal state coming into an equal union is entitled to enjoy all of the incidents of sovereignty that the original 13 had. Among those incidents of sovereignty is the ownership and control, jurisdiction over all of the land within its borders, including the land now that the federal government withholds in the state of Utah.
The series of cases that the Robert Courts has written, one can discern a pattern of emphasizing federalism and dual sovereignty, and emphasizing that states are to be treated as sovereigns.
I started off skeptical about the validity and strength of these claims, something like Professor Rotunda, and I've been frankly surprised by the strength of the claims that have been articulated.
If you were going to make it explicit, what would you say? What if you said, this land would be transferred to the United States, and the United States will keep 2/3 of Utah forever? Because we're not saying that's the way to keep you as second-class citizens, but if we wanted to do that, that would be a good way to do it. Now, you'd never write that down. If you were going to make, because nobody would agree to it. People wouldn't think it was fair.
Central government is run by states. It is a federal republic. The members of that republic, i.e. the states, must be equal in power. They must be equal in political and sovereign power. And that is the principle that is known as the equal sovereignty principle.
So the understanding that was carried over from the Articles of Confederation is that there would be new states and they would have all the powers of the original 13, and that there would be no second-class citizens. All the states would have the same, not the same population, not the same natural resources, no, but they would be on an equal footing with all the other states.
That is the overarching theory. The equality of the states is the overarching theory, and that is from the very beginning, and in fact before the establishment of the Republic, something that was a sacrosanct concept.
Second-class states. We have states that do not have and cannot ever have the powers of other states. The federal government owns like less than 1% of New York for its forts and so on, and owns 2/3 of Utah.
There have been many occasions when lawsuits have been brought that stood a low chance of success and has succeeded despite people's predictions. And this is probably best illustrated by the long march towards civil rights that began well, of course, before Brown versus Board of Education. Many of those lawsuits began at a time when the law was flatly contrary to what the plaintiffs were asserting. They were seeking a change in the law, a change in the prevailing view. And it was in that context when I said there is absolutely nothing wrong with bringing a lawsuit when many, maybe most people tell you, well, that will never go anywhere. That's the way the law has changed. That's the way justice is achieved.
The Sebelius case said flat out, states are sovereign, sometimes you have to act like it. We see a series of cases by the Roberts Court on this topic. So, do we believe that there is an opening? We do believe there's an opening.
Justice Kennedy said in one of the opinions recently, the point of states' rights is not really to protect states as an incorporeal entity. It's to protect us, the people, by dividing up power.
The dual sovereignty is always a subject that the Supreme Court is trying to get the correct balance for. It does appear that the Roberts Court has taken this issue on. So, as a lawyer, analyzing this issue with that as background and the case law that we've discussed, we believe that the current panel of the court has expressed a willingness to receive these types of cases.